It's important to understand how we win and not just the fact that we win. If you want to just find out if we're winning or losing particular Second Amendment issues, you can Google that. But I'm going to try to tell you why we're winning certain issues. In particular, the decision by the United States Court of Appeals for the Second Circuit in New York City to declare that licensing officials asking for so-called social media, Facebook accounts, and other social media information from you is a no-go under the Second Amendment. Let's talk all about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks by Hamas on Israel Teaches We Americans About the Right to Bear Arms. Check it out on Amazon. All right, so you may recall after the 2022 decision by the United States Supreme Court in Nysurfa versus Bruin that New York State with Governor Kathy Hochul threw a hissy fit and tried to throw up a whole bunch of roadblocks to law-abiding ordinary American citizens that want to exercise their right to keep and bear arms by getting a concealed carry permit to carry guns outside the home in public for self-defense. One of the ways that Kathy Hochul and the state of New York has thrown up a roadblock is they required that people applying for carry permits turn over information about their social media accounts. They had to disclose their accounts and their names, and that's what they had to do. So they had to provide a list of former and current social media accounts from the applicant for the past 3 years to confirm that the information regarding, basically, supposedly to confirm information about the applicant's character and conduct. Now, this is utter BS for a whole host of reasons. The bottom line is that if you read the U.S. Supreme Court decision in Bruin and the concurrence by Justice Roberts, Chief Justice Roberts, and Justice Kavanaugh, one thing is crystal clear, is that to the extent that a permitting regime for a shall-issue permitting regime is allowed at all, okay, which is still an open question, but for the sake of argument, we're going to assume that shall-issue permitting regimes are allowed under the Constitution for the moment. Justice Kavanaugh and Chief Justice Roberts, as well as the rest of the court, made it clear that such criteria for applicants who want to conceal carry, the criteria must be narrowly focused, must be objective, must really be binary, okay? A yes or no questions, with no discretion to the licensing officials. Why? Because essentially the Supreme Court said that in the context of, let's say, the First Amendment, no one would ever think conceivably that you have to go mother may I to a government official to pray, to go mother may I to a government official to get permission to pray the rosary or engage in mass or any of those things. Absurd. Or to post a tweet, if you will, a post on X. So with that said, that's what the Supreme Court basically said, that to the extent that a shall-issue licensing regime is okay, the criteria to get a concealed carry permit has to be narrow and objectively tailored with no discretion on the part of a licensing official. Nevertheless, the state of New York tried to play a game, and what they did is rather than say that in addition to satisfying the criteria for carrying, you also have to show that you have a special need for carrying. That's what was struck down as unconstitutional in Bruin. So after Bruin, the New York legislature came out and says, well, you have to show that you're really law-abiding and responsible and a person of good moral character to be able to conceal carry in the state of New York. And in light of that, we, the state of New York, get to use our licensing officials or our NYPD officers to engage in a wide-ranging investigation, an independent investigation into your background to make sure that you are trustworthy, that you have good moral character and the like, that your character and content and conduct, I should say, are all appropriate. And one of the ways that the state of New York was told under the penal laws that they could investigate you was that you had to submit a list of former and current social media accounts. Now, as we've talked about in prior videos, there's such a doctrine known as the unconstitutional constitutional condition doctrine. And that is basically saying that the government may not and cannot require that you waive one constitutional right if you want to exercise another. For example, it cannot say, well, if you want to exercise your Second Amendment right to keep and bear arms, that's fine, but you're going to have to waive your right to vote to get that. No, you can't condition the waiving of one constitutional right in order to get another one. It doesn't work that way. So here, the United States Court of Appeals for the Second Circuit in New York City in the Antonyuk case just decided that the social media requirement of New York State was unconstitutional. Now, I want to explain some of this stuff. In addition to the fact that this basically opened up discretionary decision-making on the part of licensing officials, which is a no-go, they also, and I want you to understand the second sort of main reason, in some ways maybe the more important reason that this Second Circuit panel decided, because it was not a good gun panel. This Second Circuit panel was generally bad on the Second Amendment. There was two terrible anti-gun judges, in my opinion, and one kind of law and order conservative that was a go along, get along guy. That's Judge Jacobs. I like Judge Jacobs. But the truth is, it was not a good gun panel, not a good Second Amendment panel. They don't understand guns. They don't understand Second Amendment law. They tried sort of earnestly to get this right. And they tried, but they screwed it all up, and the Supreme Court's going to have to fix it, and I think the Supreme Court will fix this in time, okay? But with that said, I don't want to go down that digression, and I want to just say there is some other interesting point that you need to be aware of as to why the social media requirement was found to be unconstitutional in this Antonyuk case by the Second Circuit, and that is they talk about First Amendment rights. Specifically, there's a discussion here of longstanding United States Supreme Court precedent dealing with the First Amendment's right to free speech. Now, we've talked about how the right to free speech under the First Amendment allows you to speak your mind. Yes. It also prevents the government from compelling you to speak about things that you disagree with. So government can't pass a law that says you have to make statements that you disagree with. For example, that abortion is good, or can't make you say abortion is bad, or things like that. But there's another component of the First Amendment that is well established by United States Supreme Court precedent. For example, in the McIntyre case, against really Ohio. This is a case that said that laws that require Americans to disclose their anonymous pamphleteering, their anonymous political speech, is also verboten. Specifically, they said that there is a long history going back to America's founding, even before our founding, before we were a country, to anonymous pamphleteering, to anonymous political speech. The most famous example of this is, of course, the authors of the Federalist Papers. For those of you who are astute in history, you probably know this, that there were three authors of the Federalist Papers, John Jay, Alexander Hamilton, and James Madison, who wrote the Federalist Papers. And what the Federalist Papers were was basically a series of letters explaining why the state of New York should vote to ratify and approve the brand new Constitution. So the Federalist Papers written by Madison, John Jay, and Hamilton were written anonymously under the pseudonym of Publius. That's right, Publius was the anonymous pseudonym that the three founders used to write the Federalist Papers to New Yorkers to try to persuade New Yorkers to get their representatives to approve the new Constitution. But it is these documents, these letters to newspapers, if you will, were very good recitations and explanations of how the Constitution should be viewed and trying to address the concerns about the Constitution. So it was a very important set of documents. And again, it was written anonymously. So the U.S. Supreme Court has repeatedly said that obviously under the First Amendment, there's no requirement that you disclose yourself if you don't want to. You're allowed to engage in free speech activities, including, if not in particular, political speech activities on an anonymous basis. Now, the reason why this is important is today, or I should say yesterday, the Second Circuit Court of Appeals in the Antonyuk case really embraced this theory and said that social media accounts are in many instances, if not most, are anonymous, that people use fake names, they use pseudonyms to be who they are. So they don't want to disclose this information to the government. And in this case, the Second Circuit said, indeed, there is no requirement and there's no constitutional historical standard, there's no historical tradition of firearms regulation that would require this, nor is there really a First Amendment requirement here, and there's grave concerns on the part of this three-judge panel in the Second Circuit to New York State requiring the disclosure to the government of people that want to carry concealed carry guns, right, to conceal carry their firearms. There's a requirement under the statute that they turn over the social media information about their own personal accounts, including those that are pseudonyms or anonymous. And this panel said that is verboten. That is not allowed. That clearly raises not only Second Amendment concerns, but also First Amendment concerns. And they said, therefore, the state of New York may not require and cannot require that applicants for concealed carry permits be required to turn over either former or current social media accounts to the government. So that is a bit of good news. And as you understand this argument and build upon it, it's not just a Second Amendment consideration, it's also the First Amendment. And I just want you to understand the history in the United States of this sort of confidential, pseudonyms, anonymous pamphleteering of political activity. So if you're discussing with people about keeping your name secret on the internet, when you attack Mark Smith's YouTube channel and the Four Boxes Diner and explain why his hair is fake and why I wear a wig and all that other powerful commentary I sometimes get, you, of course, will be able to do that anonymously through pseudonyms under the First Amendment. And this does speak to Second Amendment issues because it just did in the Antonyuk case in a very favorable way to our freedoms as American citizens. All right, folks, so I hope you enjoyed connecting some of these dots here. A bit of good news out of the Second Circuit that New York social media requirement is enjoined and cannot be enforced right now by licensing officials. There's a lot more we're going to have to fix in New York, but at least it's a start, and I'm happy that it's a positive start. So there you have it. Make sure you follow me on X at Four Boxes Diner. Don't forget to like this video, share it with your friends, trying to grow the channel. Don't forget to subscribe, and we will see you again very soon, I hope, here at the Four Boxes Diner.
Orders up. Table 2A.